Hi friend, welcome to the Company Law Adjudication and Appeal series. Today we are discussing Delhi ROC adjudication order for the violation of section 92 and section 137 of the Companies Act in the matter of AMN Global Solution Private Limited. This order dated 25th March 2022 and published on the 6th April. Let's see the facts of the case. Company name is AMN Global Solution Private Limited, having registered office at Delhi, and company paid up capital is 5 lakh and turnover, no financial statement is filed since incorporation. There is no turnover mentioned, and status of the company is not filing annual return or financial statement since incorporation. Facts of the case in terms of the provision of subsection 5 of section 92 and subsection 3 of section 137 the Companies Act, the office has ROC office has issued so-called notice to the company and officer in default. The notices were called upon to the so cause for non-filing of the annual return and financial statement for the financial year ended 31st March 2019 and 31st March 2020 under the provision of section 92 and section 137 of the Companies Act. No response was received from the company or director or the officer in default. Such default has not been rectified either prior to or within 30 days of the issue of the notice by this office. In terms of the provision of section 454 subsection 4, before imposing penalty for the violation of section 92 and 137 of the Act, an opportunity of being heard was given to the company and officer in default. Accordingly, this office has issued notice for hearing to the company and officer in default. As on date of the hearing, none of the company and its representative attended the hearing. As per the relevant provision of the Companies Act, as per subsection 4 of section 92, every company shall file with the registrar a copy of the annual return within the 60 days from the date on which AGM is held, or where no AGM is held in any year within 60 days from the date on which AGM should have been held. If a company fails to file annual return before the expiry of the specified period, such company and every its officer who is in default shall be liable to penalty of 50,000 rupees, and in case continuing failure, with further penalty of 100 rupees for each day after the first, during which such failure continues, subject to maximum of 5 lakh rupees. This is subsection 5 of section 92, amended with effect from 21st December 2022, which now reads as below. यहाँ पर in place of the 50,000, this penalty is the 10,000 minimum and maximum 5 lakh rupees, that is reduced to maximum 2 lakh rupees in case of the company and 50,000 in case of officer who is default. Further, subsection 3 of section 137 says if a company fails to file financial statement before the expiry of the specified period, then company shall be liable to a penalty of 1,000 rupees for every day during which the failure continue, but which shall not be more than 10 lakh rupees, and the MD CFO of the company, if any, and in the absence of any MD or CFO, any other director who is charged by the board with the responsibility of complying with the provision of this section, and in absence of such director, all the directors of company shall be liable to penalty of 1 lakh rupees, and in case of continuing failure, which further penalty of 100 rupees for each day, subject to maximum of 5 lakh rupees. This subsection 3 of section 137 got amended with effect from 21st December 2020, which now reads as below. In this case, the penalty amount is the 10,000 rupees, and in case of the continuing failure, further penalty of on 100 rupees for each day during which such failure continues, subject to maximum of the 2 lakh rupees, and all the director of the company shall be liable penalty of 10,000 rupees, and in case of continuing failure, further penalty of 100 rupees for each day after first during which the failure continues, subject to maximum of 50,000 rupees. Before 21st December 2020, this penalty is 1,000 rupees for every day during the failure, which is the failure continue, but which shall not be more than 10 lakh rupees on the company, and on the director officer in default 1 lakh rupees, and in case of continued default 100 rupees for each day, and subject to maximum 5 lakh. This is got reduced by amendment with fact from 21st December 2020. In adjudication of the penalty, in the present case, it is evident that the company and its director in default have not filed annual return and financial statement for the financial year ended 31st March 2019 and 31st March 2020, thereby making themselves liable to penal provision under subsection 5 of section 92 and subsection 3 of section 137 of the company. The company and its officer in default neither responded to the so-called notice issued nor they appear before the adjudicating authority on the date of the hearing. Having considered the facts and circumstances of case, and after taking into account factors that non-filing of the statutory return in MCA registry, which public domain is a violation of the relevant provision of Companies Act, and ROC impose penalty on company and director as per the table given below. For the financial year 31st March 2019, that is here there is 802 days default for failure to file annual return, here calculated as 50,000 minimum penalty plus 100 for 802 days, that is 1,30,200. That is maximum penalty is 5 lakh. But here impose 1,30,200 on company and 1,30,200 on officer in default. For further, for a failure to file financial statement, in that case 1,000 per day, that is 8,31,000, that is maximum to 10 lakh. So here impose penalty on the 8,31,000, and on officer in default, that is 1 lakh plus 100 per day, that is the calculated as 1,83,100, as maximum to 5 lakh, but impose a penalty at 1,83,100. That is this penalty is imposed as per the before the amendment, that is the 21st here mentioned 21st December 2020, and for the next financial year 31st March 2020, this penalty is imposed after the amendment. So impose penalty on the company, that is the 10,000 plus 100 per day into 344, that is 44,200, and on the officer default also 44,400, and on the company and officer default 10,000 plus 374 days default, that is into 100 is equal to 47,400. On officer default as also calculated 47,400. That's this penalty imposed after the amendment of the Companies Act. Here number of days calculated for the financial year ending 2020, that is the extended period of the AGM, that is from 30th September 2020 to 31st December 2020 till 8 February 2022, and from 31st January 2021 till 8 February 2022 for the annual return financial statement respectively. Company and its director are hereby directed to pay penalty amount as per the column given above. The company and its director are hereby directed to rectify the default immediately from the date of the receipt of the copy of this order. The notices shall pay the said amount of penalty through online by using the MCA website in favor of pay and account office within 90 days of receipt of this order, and intimate this office with proof of the penalty paid. Appeal against this order may be filed with the regional director within period of the 60 days from the date of receipt of the order in form ADJ. Thank you so much for watching this update here in adjudication procedure. ROC apply both penal provision before the amendment of the section and after the amendment of the section. Thank you so much for watching this update.